Welcome to In Your Defense with Amy Bingham.
Hello and welcome to In Your Defense with Amy Bingham. My name is Kevin Rosenquist, and today we're going to talk about Amy's background and sort of her career in law and how she's gotten to where she is. Amy, it's so good to see you. Thanks for being here.
Good morning. It's good to see you as well.
Let's start with some background. Can you share what inspired you to pursue a career in law and maybe how your journey led you to specialize in such a broad range of legal fields?
Sure. So as young children, we're often asked, what do you want to be when you grow up? And I think sometime around preschool, I chose lawyer.
Wow.
Didn't know.
I'm pretty sure I was still saying like superhero or something.
Right? Right. And I picked lawyer and stuck to it. And it was interesting because we didn't know any lawyers. I didn't have any lawyers in the family. I probably had met one. My father was in the military. And so we had the opportunity to live overseas a few different times. And so part of that process involves talking to people about what's expected of you when you arrive and what kind of laws you have to follow and all sorts of other rules and regulations and things that are probably way beyond a toddler and younger children. So that may be where I learned about lawyers. I'm not sure. So I continued sticking with lawyer. I explored maybe being a teacher for a short period of time when I was in high school and decided that that probably wasn't for me. I would probably yell at the kids too much or
It definitely takes a certain kind of person to be a teacher. I commend anyone who could do it because I couldn't.
Right. I like the little kids, but they get me in the middle school age and my patience waned.
Yeah, attitudes galore.
Yeah, exactly. After I graduated from high school, I went into college, did political science as my undergraduate degree, and just started studying for the LSAT and getting ready to go to law school. I took the LSAT and then was accepted into several different schools, but ultimately chose to go to Southern California to the University of Laverne College of Law. They had a really good program for litigators, which is what I knew I wanted to do. I knew I wanted to be in the courtroom. And so that is what I chose to do. So I graduated in 2006. And as you're aware, 2008 was the start of the recession, and people were ready for it, at least in the legal profession. So I was licensed to practice as of 2007. And during that time period, a lot of the major firms were laying off associates and weren't hiring, battening down the hatches, if you will, to get ready for the recession. And so I started practicing with a small attorney, a firm that did a little bit of civil litigation, mainly construction defect work. And so I spent a lot of time doing construction defect work, which was really interesting litigation. Typically involves a neighborhood or a developer who is being sued by a neighborhood, new construction typically. In their contracts, they always bring in all the subcontractors that may have worked on the project. And so one of my main jobs was representing these subcontractors in this litigation. And some of these subcontractors didn't have any allegations against them about what they had done. Their work was fine, but they were brought into the lawsuit anyway so that they could help pay the costs of the developer. I also did real estate litigation. Part of construction defect, you learn about real estate and real estate law. And so I started dabbling in that a little bit and spent quite a lot of time doing real estate litigation, everything from property disputes to contract disputes between buyers, those kinds of things. I did start doing criminal law when I was still practicing in California and really enjoyed it. I found the time in court to be really fun for me. Probably not for anybody else, but lawyers like it. Otherwise, why would we do it, right?
That's true. If you didn't like it, then you're probably in the wrong profession.
Yep, exactly. And so that's where I started criminal law. Then I transferred up to Oregon in about 2021 and became licensed here.
Wow. I still can't believe you thought you decided to be a lawyer at that age. I have a preschooler and he says the weirdest things all the time and I don't take any of it very seriously.
I know. I imagine my mom probably thought she'll never do it, but then I did.
She probably thought you just heard it somewhere at school or something or daycare or wherever. One of your friends said lawyer and you're like, that's what I want to do and not even think much of it. But yeah, that's really funny.
Do we even know what that is? Nope.
No, but I'm going to do it. And you did.
And I
That's
did.
impressive. So you have experience handling Measure 11 and Jessica's Law cases. Can you explain what these laws entail and some of the unique challenges they present in criminal defense?
Absolutely. So Measure 11 is a ballot measure that was introduced in 1994, and it was intended to set forth minimum sentences for certain serious crimes. And it passed and became law in 1995. And it includes arson, assault 1 and 2, attempted aggravated murder, attempted murder, kidnapping 1 and 2, manslaughter 1 and 2, murder, rape 1 and 2, robbery 1 and 2, sexual abuse in the first degree, unlawful sexual penetration in the first and second degree, sodomy 1 and 2, using a child in a display of sexually explicit conduct, and compelling prostitution. Very serious crimes, very serious allegations. And the voters wanted judges to not have the discretion to give someone a shorter sentence. And so that's essentially what Measure 11 is. Jessica's Law was named after a young girl in Florida who was sexually assaulted around, I believe, 2005. And she was assaulted by someone who had been convicted of the same conduct in the past. And so Florida instituted this law that would require a minimum sentence for anyone who was convicted of sexual abuse against a child under the age of 12. And a lot of states, including Oregon, have adopted that legislation. So that's what Jessica's Law is.
Okay.
There are unique challenges to these because negotiations with the district attorney are really important. If you are able to use mitigating information and can negotiate with the state, you might be able to get the state to reduce charges and take them out of Measure 11, which is what we call it. A judge doesn't have the authority to do so on his own. A judge can't decide, instead of the 300 months or 25 years you're going to get for Jessica's Law, I'll give you 15 years instead. They don't have that authority. But a district attorney, depending on circumstances of what may have occurred, might be willing to lower a charge or give you what's called a lesser included charge. And that is still pretty serious and can still come with, high amounts of time in the Department of Corrections, but isn't subject to the same rules as a Measure 11 or Jessica's Law. One of the other important things to note about Measure 11 and Jessica's Law is that people who are convicted of those crimes do not qualify for early release. So they won't be able to get out early. They don't qualify for what we call good time, which is for every certain number of days that you serve, you get a day's credit, which essentially lowers your sentence. And they don't qualify for some other programming. And so if you can get involved fairly early and have all of the information necessary to negotiate or to mitigate the situation, then you might be able to negotiate a better outcome than someone would get otherwise.
Okay. And then you have civil litigation experience too. You talked about construction defect litigation and business litigation. What are some of the common misconceptions about civil litigation that you encounter?
I think the most common is that there's a winner. There's never a winner in civil litigation. Often people think if they win, they're going to get a payout. They'll get a judgment and they'll get back whatever money it was that they lost or what they think that they're owed. In reality, at the end of civil litigation, at the end of either a settlement or a trial, what you get is a decision of who's liable. And that results in a judgment. And a judgment then has to be enforced. And that enforcement is not easy and it's expensive. And it can take time. And if the person you have gotten the judgment against has no money or no property, no assets, you're probably never going to get paid.
Right.
Another thing that people think is that a judgment may last forever, and it doesn't. They typically expire around 10 years. You can petition the court to get that judgment renewed, but it's still not a guarantee that you may get paid. You might be able to garnish bank accounts or wages or get people's income taxes back, their returns or their refunds. You could get that money, but you have to weigh whether it's worth it or not. People also think that it's a good idea to represent themselves or that they can represent themselves. And it might seem a little self-serving for me to say, don't do it. I went to law school, so I learned the rules.
Right.
I know the procedures. I know
Yeah.
the judges. I know a lot more information than you would know. And a person is perfectly able to represent themselves. It's just not a good idea. You are held to the same standards that anybody else would be held to, which means that you have to understand the evidence code. You have to understand what an objection is and how to do it. You have to understand discovery and what the rules are around discovery, the timelines and deadlines that are included in that, motions, and how to talk in court. There's a lot of things that are involved that it just makes it not a good idea to represent yourself.
Yeah, I've heard that before, that judges aren't going to go easy on you just because you're representing yourself. It's not like they're going to be like, well, this guy's not a lawyer, so, I'll give him a little leeway. No, you gotta know what you're doing. They're going to treat you just like any other lawyer.
Exactly. And
it's terrifying to me.
It's scary if you don't know what you're doing. It's certainly nothing like Judge Judy or the other judge shows on TV. Those are always very entertaining. And when I was in law school, we had Judge Judy on in the break room all the time. We all thought it was so entertaining and fascinating. The story. That's why they're on TV. A real judge will not tolerate that kind of behavior.
Right. When you're going to trial with a case and you see someone representing themselves across the way, what goes through your head?
Poor sucker.
That's awesome. That's awesome.
I try to help when I can. Yeah, I will give someone a tip or two.
Be respectful. Yeah, sure.
Right.
Yeah.
Hey, maybe you ought to go visit the law library. There are law librarians there who might be willing to take you through some of this stuff that you need to know.
Yeah.
But really, my typical advice to them is to call the state bar and ask for a referral to a lawyer. And for people that can't afford it, I'll point them to legal aid or the modest means program. There's people willing to help.
Yeah. Right. So you do estate planning and probate too, correct?
I do.
You are doing everything. Why do you believe estate planning is often overlooked by individuals and families? And what advice would you give someone starting this process?
Sure. I think people believe that they probably don't need estate planning. I don't have $1 million. I don't need to have a trust. I don't need to have a plan put in place.
Sure. I've said that. Yeah.
Or I'm 20 and I certainly am not going to die till I'm in my 80s or 90s. So I have time. I can wait. What is interesting is that less than a third of Americans have an estate plan. And the people that probably need an estate plan the most are those people who are 18 to 30. The reason is that age group tends to participate in risky behavior, extreme sports. They travel a lot. They will go out partying with friends. And these activities result in accidents a lot of them.
More higher risk, yeah.
And one of the things that probably an 18 or 19-year-old doesn't understand is that if you are in an accident and you cannot speak for yourself, you can't tell the doctors what type of treatment you want, they think, well, mom or dad can do it. And that's just not accurate. Mom and dad lose their legal authority over you when you turn 18 years old. And so mom or dad would have to go get a court order in order to make decisions on your behalf if you don't have an estate plan in place. That doesn't necessarily mean that you need a trust or even a will in those situations, although I would recommend at the very least a will. But at least you would have in place an advance directive, which would tell what your wishes were as far as what would happen to you in certain circumstances, whether you should be fed, whether you should be kept on life support or not, whether you want a risky operation or not, who you want to make those decisions. So those are important for that age group. When you pass on, if you die and you don't have an estate plan, that's called dying intestate. And what that means is that the state in which you die has a statute that will tell you tell someone what is going to happen to anything that you may own. And it's going to decide who gets what you own by statute. So you get no control over that. Your family has no control over that. It is all done by statute, and it has to be done through the probate court. And probate takes a long time. In order, the minimum of 4 months, and it can last years. It's also expensive. And there are statutes that determine how much a probate attorney is going to be paid and determine how much your personal representative may be paid. So it's taking away control from the person and giving it to the state. So a will tells the state what you want to happen with your stuff, if you will. It will instruct the court who you want to have what and how much of what. But a will still has to go through probate as well, unless you are under the statutory minimum. So in Oregon, if you have assets that are valued under $80,000, you can avoid probate. Or if you have a piece of property, real estate, house, fishing cabin, whatever, that is valued under $200,000, then you can avoid probate. Over that amount, you have to go to probate. Also, it's important to note that it isn't necessarily that you own a house free and clear. If you have title to a house and the house is valued at $300,000 and you owe $290,000 on the mortgage, you still would have to go through probate. So that is important. The other thing to note is that with a will it is public record. So once a will is put into probate, anybody can go down to the court records department and get a copy of it. So there's no privacy with a will.
Yeah.
With a trust, it's private. You don't have to file that with the court. You don't have to go through probate. It can save you a ton of money and a ton of time and give you full control over what happens to what you own. The other important thing to note that people tend not to pay any attention to is assets such as social media. So you own your social media accounts. You own what is on there, and you have to decide what is going to happen to that when you die.
Wow. Yeah, I never would have thought of that.
Yeah. And you should also think about, is there anything in my house that I wouldn't want someone to find?
Like what, Amy? No, I'm just kidding.
Go through my bedroom, or do I want my mother to do it? These are, things that you have to keep in mind when you are.
That's a good point. You've been described as a passionate advocate for your clients. Can you discuss how compassion plays a role in your approach to sensitive legal issues?
Absolutely. So I like to treat every single person as a human being and treat them as I want to be treated. I try and remember to be kind to everyone as often as I can. Sometimes I need reminders like everybody else.
Sure.
I don't want to judge anyone. It's not my place to judge them. That is, if we're talking about some sort of criminal allegation, that is the job of the jury or a judge only. That's not my job. My job is to help somebody get through the situation with the least amount of stress and the most amount of understanding that they can. I want to make sure that people understand exactly what's happening and when it's happening. And if I can give answers as to why it's happening. I find that a lot of times there are underlying issues that have resulted in whatever situation somebody is in. And if I can find resources for that person or help for that person or point them in the right direction for services, then I'll do that. Because if we don't solve an underlying issue, the result of that is going to continue. And you're going to see it popping up again. And everybody deserves to be treated with kindness and respect. We're all human beings. Nobody is, better than anybody else. As hard as it is to be equal in this society, that's what I strive for, to treat everybody with the same level of kindness and respect.
If only everybody felt that way, it would be a much better place. Well, thank you very much for joining us on In Your Defense with Amy Bingham. If you'd like to reach out to Amy, visit her website, amybinghamlaw.com. And of course, don't forget to like and subscribe to the channel. We love having you here. Amy, so good to have you here. I look forward to the next one.
Thank you. Me too.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.